If you have made a good impression during the interview, you will be offered a form of cooperation, such as an employment contract. When you're hired, you will have to sign a document containing the following elements: working hours, the type of contract, the duration of the contract, which could be either a fixed term or a permanent one, the job title, meaning the role you will play in the company, the place of work, and of course the salary. Before signing any document, take your time. Read the contents carefully, and if you have any doubts, ask for help from a consultant or an institute that assists workers, such as patronages. Also remember that you are entitled to always have a copy of the documents you sign. Often the employment contract includes a probationary period, which will help both you and the company to understand if you're suitable for the job. The probationary period must have a defined duration, which depends on the type of contract and cannot be extended, has the same rights and obligations as in the employment contract, and must be paid. The employer must notify the employment center of the start and termination of the contract by dismissal or resignation, the extension of a fixed-term contract, the transformation, and other types of employment relationships. Remember that you're obliged to provide the necessary documents and to inform the employer if there are any changes, such as if you have changed your residence. Now let us look at another very important document, the payroll, which you will receive when you're paid for your work. The payroll is a document that summarizes the employee's details, the reference period of the working activity, the elements of remuneration, deductions, and the summary of holidays and leaves of absence. By consulting the payroll, you can check whether the pay corresponds to the work carried out. But be careful. Bear in mind that the remuneration will be expressed in two ways, a net total and a gross total. The net total is the compensation that you will receive in your bank account. The gross total, which is higher, actually contains the part for taxes and contributions, which will be paid by the employer to INPS. These taxes will entitle you to a pension and other salary supplements in case of unemployment, for example. Your main paid rights also include holidays and leave, weekly rest, marriage, maternity and paternity leave, medical leave, and accidents. In the event of illness, the employer has the right to request a home visit, through which he can ascertain the situation. Remember that, in the event of illness, there are rules to be respected, such as being at home during certain hours. Your employer must respect the hours set, even if he may ask you to work more than the hours set. In this case, the extra hours you work must be paid with a premium or be shown as compensatory hours. If you have to be absent from work due to illness or other reasons, or if you're late, remember that there are specific ways to communicate and justify your absence to your employer, depending on the case. Workers, like all citizens on Italian territory, have the right not to be discriminated against on the basis of their gender, age, origin, or religious beliefs. Working in Italy without having signed a contract or without the employer having communicated your employment to the competent offices means that you're working illegally. In this case, you should know that your employer is breaking the law and that your rights must be protected. Also remember that working illegally means that you will not be able to access the benefits that the state guarantees to regular workers. Even if you have signed an employment contract or if you have opened a VAT number, remember that if you're asked to work beyond the limits of your contract or in sectors that are not covered by your VAT number, it is a form of irregular employment. If you have any doubts or you would like to know what your rights are, you can contact a body that protects workers' rights. trade unions, employers' associations, and lawyers. The employee is considered to be the weaker party in the employment relationships and does not risk any sanction if he is found to be working illegally.